item, my lord, item 23, my lord. The matter, only the expertly matter, my lord. Already listed on more, my lord, 5 or 6 times, my lord, not 6, my lord. So if possible for upgradation, my lord.
23.
At 2 p.m. if possible, my lord.
2 p.m. the bench will not be there.
Oh, I'm sorry, my
We'll
lord.
try to see.
Uh,
We're taking a note, we'll try to see.
my lord. Obliged.
May it please, my lord, with regard to item 24, it's a writ petition criminal matter, my lord, preventive detention. My lord, I had filed 2 affidavits yesterday, my lord, which may kindly be allowed, my lord, to be requisitioned. My lord, prayer 24. My lord, prayer for upgradation if it is possible, my lord.
It will not be possible.
Obliged, my lord. Obliged.
May I please, your lordship? Item 1, kindly matter message after 3 weeks. The engaged counsel, Mr. Arkorim, is out of station due to some medical emergency. His name also shown, leave note of advocate list, Arkorim.
Item
Item 1,
1. Okay.
after 3 weeks, any date, my lord.
Okay. Both sides are represented on the prayer made by the counsel for the petitioner. The matter is adjourned today. Based on due date after 3 weeks. Okay.
Right, I victim mentioned item number 9, my lord. I have similar where I'm paying for adjournment for the day, my lord. And the next week is
9.
9.
Okay. As well for the day as paid for the land counsel for the petitioner. You say both sides are represented. Okay. 9. Okay.
May it please, your lordship. Lordship, item number 18, the petitioner already died.
Item
18, lordship.
18.
Yes, lordship. Bharuti Sarkar. So this may kindly be closed, lordship, and if later on they came, lordship, liberty may be granted to file appropriate applications.
We have the death certificate.
No, because
they
we'll have to close it without making any observation.
Lordship.
It will come in its own merit. They don't
I have
want to be
asked them
impeded.
to, bring the legal heirs to file
Representatives do not want to be impeded right now.
Lordship.
Okay. Item 18.
The engaged counsel who conducted before the learned tribunal, he informed me, lordship.
Okay. Heard. This is our Chaudhary, learned senior counsel assisted by so for the learned counsel.
S.E. Murtaza.
Murtaza, learned counsel for the petitioner. Also heard so for the respondents. Next para. The upon instructions, the learned counsel, learned senior counsel for the petitioner has submitted that the petitioner Bharati Sarkar, alias Bharati Bala Sarkar, had died on. When did she expire?
Lordship only informed that she expired, and accordingly we have informed them to bring the legal heirs, lordship, but they are
She
not
has expired. But he has not been informed of the date of death. Moreover, comma. On a query of the court, the learned senior counsel for the petitioner has submitted that there is no instructions as to whether the family members want to be impeded, want to be substituted as the petitioner, next para accordingly, as prayed for from on death of the petitioner. The petition stands vetted. And disposed of.
Lordship, may it please your lordship, I have another item, item 27.
Disposed of or as abated.
Lordship, I have another item, item 27, lordship. On 17/7, there was an order passed and granting interim to the petitioner, lordship. Accordingly, we appeared, and thereafter we came to know that the police station is a different police station, but somehow we have mistakenly written the earlier police station. For that, I have filed one IA. If your lordship, before rising, take up this matter.
Okay.
Obliged, lordship.
Item 2, promotion.
There is no representation from the petitioner. How all the respondents are represented. Next para. For ensure justice, the matter stands adjourned today. It is made clear that if the petitioner remains unrepresented on the next date of listing, adverse orders would follow. Next one, list on. Give a date after 2 weeks.
Item 3.
Please, Your Lordship. Lordship, can you pass over this matter for 10 minutes?
I mean, okay.
With the new ex parte cases which are coming up now, can these be again put together on a later date? Lordship?
One by one, we can.
Or
Otherwise, everything gets piled up and.
This one, item 2, 3 is a ex parte one, Lordship.
Yes, this was expired, I think expired.
Making a note of it. Item 4 note
Yes,
ना?
before.
अच्छा, आपने खाली ये तो दीजिए, imprint order to दीजिए, आपने bail पाई दीजिए.
At page 27, my lord, impugned order, my lord. My lord, the evidence of the defense witness of my lord, Lat Mondal has been closed, my lord, on second date, my lord.
Lordship,
Even
it
then,
has
we
been
have
closed, but
taken
in
steps.
matters of 2018 Lordship, the case number, if Lordship notices, it is of 2018 Lordship. How much more time is required? We have not annexed the other order sheets from the beginning. Other sheet dibble लगे, किसी का हाथ वैसे हो जाती है.
Why you given part of the order sheet?
My lord,
Why you have given one part of the order sheet?
Only the 26.
my lord, at
One has
first,
been
my lord,
given.
matter was fixed on my lord for,
This is, she is right. The 2018 case of 2018.
yes, my lord.
Why suddenly you are giving only few of the order sheet and not giving us others? We can't appreciate what has happened. How much time you have taken,
My lord,
we can't understand from this.
My
When
lord,
the
my lord,
proceedings
kindly-
started, we need to know that, Lord.
my lord, kindly have a look at this, my lord, order dated, my lord. Order dated, page 20, my lord. On the first,
No, why should we start looking at in the middle of the order sheet? Why not, what prevents you from producing the entire order sheet?
at first, my lord, the case was fixed for my lord, on
When
20.
No verbal explanation.
when
You
was-
don't put the order sheet, we are not taking it up.
And when he was, he
All-
served with the notice,
all-
Lord.
all sides are represented. Yeah,
Already, my lord,
as the petitioner has not annexed the entire order sheet of the proceedings of FT case number 1395 of 2018, pending before the learned foreigners tribunal number 1, Bolkata, the court is inclined to direct the petitioner to produce the entire order sheet as the proceeding is of the year 2018. Next, give a date, next Friday.
Obligement.
Item 5.
Sorry, madam. Item number 2, madam. Already, okay, we'll take it up after this. We have called item 5.
Already fixed a date, man.
No, we'll take it up once we are here.
May I please, your lordship, order at page 69,
50,
69, lordship. Authority person at page 70.
okay.
11.5. Like it, huh? I just said it.
Mr.
Yeah, legal.
A.R.D. counsel for the petitioner and so and so for the respondents. Opinion at page 69 dated 11/5/2026 passed by so and so in FT case number so and so corresponding to reference number so and so by which the petitioner was declared to be a foreigner of 25 to 1971. Notice returned within 4 weeks, extra copies, all for the records. The prayer for bail is opposed by the Government Standing Council for the FT matters. Considering the projection, and it's time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police, Border, Borpeta. List after 4 weeks.
Item 6.
Call item number 2 also. Item number 2, the lawyer is there.
May I please, your
Okay, we'll finish this new matters only. Okay. Yes,
lord, impugn opinion, your lordship will find at page number 111.
yes. You are saving ink.
My,
That is good to see.
my,
Not fill up the page numbers. Yes. Which page?
my lord, page 111, my lord,
Connected 10 lordship.
and accepted. This is of 2015, my lord, opinion.
Okay, you have to wait for some time for bail.
But in fact, the petitioner earlier also approached me, lord, in time, my
So,
lord,
but this is not in time.
my lord,
This is 24/4/25.
my lord.
You crossed that. This was filed on 7 July 2026.
No, my lord, page number 150, my lord.
Hmm?
Page number 120. Earlier it was filed, my lord, and it was withdrawn, my lord, and subsequently it was filed after because there were some, my lord, typographical mistake and other mistake, my lord, on the part of
Oh, okay, okay.
the other permit.
Heard Mr. A. Anil and
Yes.
counsel for the petition and so and so for the respondent. Same order. Opinion is at page 111 dated 24/4/2025. Yes. There are 4 reference numbers, huh? I'm putting it one, so and so, and this is another. Passed by so and so in FT case number so and so, IMDT case number so and so, FT case number so and so, and this is so and so. By which the petitioner was declared to be a foreigner post 25/3/1971 stream. Next, the counsel for the petitioner has submitted that the petitioner had previously opposed this court by filing WBC 331 of 2026. On account of certain defects, the same was withdrawn by order dated 30/1/2026. And accordingly, the matter has been refiled again. Next one. Same order, bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Dhubri.
My lord. It will be South Salmar, Mankasar, my lord.
Okay, South Salmara Mankachar. South Salmara Mankachar.
I'm obliged. my lord.
7,
May I please, Your Lordship?
Yes, Mr. Udin,
The page 68 is the opinion law.
68.
Yes, ma'am. Some delay, my lord, but I have explained, my lord, paragraph 22, my lord.
Okay. Heard Mr. Udin, learned counsel for the petitioner and so and so for the respondents. Here is at page 68 dated 11/3/2025, passed by so and so in case number so and so, IMDT reference number so and so, by which the petitioner was declared to be a foreigner post 25/3/1971 stream. Notice returnable, give a date after 4 weeks, returnable on so and so, extra copies in 2 days, call for the records. The following email address. Next one, the prayer for bail is, the prayer for bail shall be considered on receipt of the tribunal's records. Next one, in the meanwhile, if the petitioner, namely so and so alias so and so is apprehended, comma, she shall not be deported out of the country without order of the court. Full stop. The petitioner shall produce a certified copy of the order before the Superintendent of Police, Border, Bongaigaon, to bring the order to the notice of the said authority. Next one, list on so and so.
9 September.
Time clock.
Your lordship, I'm preferred typing, your lordship.
Sometime.
Obliged, your lordship.
May I appeal, Lordship, the opinion is, judgment is page, Lordship, 51, Lordship. Lordship, there is some delay, Lordship, I have explained paragraph 14, Lordship, you are the psychiatric patient, Lordship, but I have also added some text also. Paragraph 14, page,
Which page is the medical company?
Lordship. Paragraph 14, Lordship, of my petition. Some petition also I have signed. Page 51 to page 63, Lordship.
submitted is, it's all about the voters list of the paternal uncle and aunt's lordship, nothing to do with the family. In the WH is not mentioned when she was born, when she got married. In fact, we were searching out for that.
So we start, yeah. As per the submissions of the non-Islamic also for the border entry matters, you have not been able to connect your, although you have documents, but there is a total failure to link yourself.
My lord, school certificate, my lord, and marriage certificate also the link with my father, and my father also linked with my
But
grandfather,
that
my
is
lord.
not exhibited. Once that is not exhibited, you see everything collapses. Although you have
my lord.
documents,
Certificate is not even proved, Lordship.
Mrs. Verma also does not, Mrs. Verma also does not oppose your stand, but it says that only not being able to connect. You're not disputing any of your documents. But still there is no connect.
Allow me to verify that record, my lord. In deposition, my lord, in the code by the DW2, DW1.
Show it to you.
Clearly stated, my lord, in the deposition and also in his affidavit in chief, my lord. The petitioner is his daughter, my lord. And the document also shows my.
You see this cross-examination. Now, as per your writ petition, what is your age?
My lord,
44 years old.
4 years,
44
the time of
in the year 2019.
So her date of birth would be 1975.
1975.
75. That matches with the school certificate.
the school certificate also, my lord.
So there's difficulty. That's why we are
And
asking.
my lord,
Here,
father
Yes, that's why we are asking you a question. This. Nobody has that. This. Look at this. This part. Does it come? Right.
Deposition
Page
note.
114.
Yes, Lordship.
Page 114 is the cross of BW1. Somewhere he says he was born 40 years ago. Here she will say
Somebody will have to read this now. Sure.
whatever is that. This is about birth 40 years ago.
No.
In the query to the court, she says she was married 30 years ago. 30 years ago would be, that means she was married at the age of 10 years.
Change.
If this statement is correct, that she is born in 1975, then the mother's presence comes only in 1977 for the first time. So everything is very chaotic.
The father's first two voters list created all the doubts, Lordship.
The problem. Once
Now,
we
this is not before me, otherwise I would have submitted on this also, Lordship. And Lordship, this
after two
certificate
pages,
of-
there is a court recording of the under 165. There she gives that statement of
Yes, ma'am. মোৰ জন্ম আজিৰ পৰা 40 বছৰ আগত হৈছিল।
that is in
মোৰ
2019,
দেউতা তচিৰ আলী
maybe 17.
লস্কৰৰ জন্ম
Has she
Police box
stated
also,
on what
yeah.
basis she has given this certificate, Lordship? On what basis? Whether from information, register, records,
which one?
this has DW2.
This is the DW1.
One, the headmistress, has she stated?
Administration does not come.
Oh.
The father and the projected father,
Then
is
yes.
these two came.
The petitioner herself is,
So therefore, the presence of the mother for the first time in 77, that's creating a difficulty. The family is not there together in the written statement,
no,
but the in his cross-examination, the father comes and states about some people we will not be able to connect because entries in the entries in the voters list not having been proved, we have not taken note of that. So I'm missing out on that. The evidence tendered by the father in cross-examination. But the connect is still not there. We can have a short break and come back. Yes.
My lord, exhibit 14, 135, my lord. Is establishing the link of the petitioner father with the grandfather.
Exhibit?
Exhibit 14, my lord, 135 page.
Exhibit 14 is the Jamamandi.
Jawabani.
But you see, the Jamamandi is not approved. The reason is that there is no connect of this Jamamandi with either of the two exhibited sale deeds.
And my lord, can you see exhibit 15, 106,
Yes,
page number,
yes.
says 68, 69.
You see,
The
exhibit
father of the
15,
petitioner name was there, my lord.
no, we understand, but there is no connect with the Jamamandi. You see, if the grandfather had a land, it would be inherited by the father and the other siblings of the father.
And Jamabandi also established that there is a land.
But where is that
What the
land?
name?
Because, no. It's very difficult to accept your proposition. The reason being that this Jamamandi is of the year 1997.
Yes, well, there was
How do you
a
connect
record of
with the land which is prior to 71? How do you connect it?
uh, 1968 and 69. What the sometime, we keep the other record of the land matter, and we take the 1968-69 record matter. It clearly shows the link with the father matter,
68, 69,
69, page 106.
page 106 of the
The exhibit 15 matter.
where do you get this 65, 66?
Sixty, 68, 69. 106. 106 page.
Yes, we are looking at 106.
One. All the brothers' name is there.
No, but this is a Jamamandi of what do you call the corrections made in the year 1992, 93. And how do you connect this with the land which you are holding? This is something we are telling you again and again, that you have a document, but how does it link to this exhibit 15 and 16?
Your 15 and 16 prove that there are land, my lord. In the name of the father of the petitioner. It's a revenue record, my lord. Lands are there.
Sale deed is not a revenue record. Sale deed is a private document.
Private document, what Jama only is the government document, my lord.
Yes,
Land document.
but please connect it to a document which has its genesis before 71.
The 68, 69.
Hmm?
Land, my lord. To the name of the father of the petitioner, my lord. As legal heir of the Abdul Jabbar, my lord.
Okay.
Or my lord, the remand the matter, my lord, for
For remand, you'll have to make out a case for remand.
father himself, my lord, came to the tribunal and said that he is my daughter. And Abhinama also,
Hamidnama was not exhibited by the Qazi.
and
Hamidnama not exhibited by the Qazi.
so my lord, he was under the rule, my lord, Registration, under the Registration Act, my lord.
No, then you are way off. You have to read the Muslim Marriage and Divorce Registration Act and rules. That act says under 51 that if the marriage certificate is required to be proved, it has to be done only by the Qazi.
My lord. This is the Qazi seal is there, my lord. Qazi seal and signature is there, my lord.
It's something like this, that I will have this and say that this is the handwriting of the of Queen Elizabeth.
The seal of the Muslim.
But
Muslim
if you
register.
don't, Mr. Hatia, if you don't read this act and rules, how will you present
My
your,
lord, my lord,
how will you do it?
my lord. Lordship.
When there's a requirement of law to do something in a manner prescribed, it has to be done in that way, or no, not at all.
Even the matter, my lord, is proved there, my lord.
See, it's a yellow flag.
Section 50. Yes, 409. That Qazi is only seven. Qazi is particularly.
Always good not to let us read. It is always
Well,
better not to
must
let,
have better,
not to allow us to read. Now you see, you made us read this Kabin Nama. A strange thing has happened. The name of your grandfather is now written as Abdul Jalil Mazumdar.
Abdul Jalil was a name, bridegroom's man. Abdul Jalil Majumdar, the husband of the petitioner.
Husband of the petitioner.
Yes,
But where is that
But-
Mazumdar in your?
my lord, is the eight, paragraph 8, Basit, Basit Ali Laskar Haji Abdul Jabbar. Is the father name of the petitioner.
Which document you are referring?
Page number 40, my lord, English translation, and page number 42. maybe-
No, in your pleadings, how have you introduced your husband? Husband is not introduced as Mazumdar.
Abdul Jalil Majumdar, bridegroom, and his father.
You see, this is with regard to a certificate.
Name of the bride.
No, come to the written statement. If I have read wrongly, then have I
That
read
one
the,
also stated his husband, Abdul Jalil.
yes.
Abdul
The
Jalil.
written statement, let me see if I have forgotten, I made a mistake, it's .46 onwards is your written statement.
Yes, my lord. Yes. Wife of Abdul Jalil, alias Abdul Jalil Majumdar.
Where, which page?
At page 46, my lord, written statement of the opposite party, Musammat Lutfa Begum, wife of Muhammad Abdul Jalil, alias Abdul Jalil Majumdar, daughter of Muhammad Tasir Ali, alias Tasir Ali Laskar, alias Muhammad Tasir Ali Laskar, permanent resident of village.
Okay. But it's not there in the statement, so this is I have missed. Okay. Okay, we'll close the matter then.
Thanks, my lord. Let- I have lot in the queue now, my lord.
Ask her, in the office there is a locker here. Ask him to paste it. This is an old document. Everything is getting apart. Just have it pasted somewhere. This is lost, it will be lost forever. Confident have it done, huh? This
Yes, anything more you want to say?
No, Lordship. Already pointed out, there's no link with the father, and father has no link with his own father.
This case it is very sad because the documents are there.
Document, but not proven. It's a
My lord,
dispatch of everything, Lordship.
You one chance, my lord, remember the matter.
But this area here, the petitioner and also for the respondents. Pursuant to order passed earlier, the records of the tribunal is received. So as the matter relates to the year 2019, the matter has been heard at the motion stage. If submissions are concluded, judgment reserved, or order reserved. Okay. Pull up.
Stamping item 3.
Lordship here also. Opinion is of 2014, Lordship. So Lordship, in the morning also, we had a matter where the opinion was more than 8 years. So the same order may be passed since the respondents are going to file affidavit on those. On the grounds Lordship has already stated. That was item 11, Lordship, in the morning.
Heard Mr. S.A. Ahmed for the petitioner. And so for the respondents. Next panel. After a lapse of 12 years, the petitioner has assailed the opinion dated 11/6/2014. Passed by the learned, that is page 86, passed by the learned foreigners tribunal, Jorhat, in reference number so and so. I take part in the page. I have given a tick mark in the page. Reference number so and so, IMDT inquiry number so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971. So, but this is a contested case, I believe.
Contested, my lord, earlier, the case was pending at Gauhati. In Gauhati, she appeared and filed a written statement, and she was examined as DW1. Her father was examined as DW2. Thereafter, my lord, the case was transferred to Gauhati.
Okay. Okay. Next para. Next para, the learned study counsel for the border and FT matters has proposed issuance of notice in the present writ petition. As the same has been belatedly filed after 12 years.
No. That is clear.
And
Yes.
accordingly, she prays for time to file an affidavit in opposition in the matter. Next para, be that as it may. Keeping the issue of maintainability open. The court is inclined to issue notice returnable on due date after 4 weeks. Requisite extra copies of the writ petition be served on the learned CGC State and Learned Department Council within 2 working days. Next, the relevant records be requisitioned through the following email address of the learned tribunal. Next, the prayer for bail shall be considered on receipt of the tribunal's records.
He was
Next
taken
para.
into custody
Okay.
on 25/5/2025.
To stop. It has been submitted that the petitioner has been taken into custody on
25/5.
25/5. 2025.
25.
And she is presently at Lost Debt
Holding center at Matia.
and the transit camp, Matia, Gauhati. Next para. Accordingly, the court is inclined to provide that the superintendent, transit camp, Matia, Gauhati, receipt of a certified copy of the order, shall not release the petitioner from the from its custody for expulsion from the country. Full stop. Next, the petitioner shall bring shall submit a certified copy of this order to the superintendent, transit camp, Matia, Gauhati, to bring the order to the notice of the said authority. Next, list on solution.
In September.
My lord, regarding bail, my lord,
Bail we are not considering right now.
on receipt of the PCR.
We are given we said that we will consider on the receipt of tribunal's records.
Oblige.
Time being item 8.
May I please say, Lordship? Lordship, the case of the petitioner is that they were declared as foreigner post 1971 stream.
Which page is the opinion?
Lordship, Lordship, actually, my case is that Lordship, the petitioner, Siratul Islam, he was declared as Indian Lordship. With petition number 1555/19, page 57, Lordship.
67.
Page 57. The High Court order, Lordship. The entire family was declared to be foreigner, Lordship. Petitioner, proceeding number 2 to 9 were declared as Indian after they have contested the case. Proceeding number 1 has already expired, Lordship, but the member was totally silent about this. Even though in a written statement, page 16, Lordship, they have brought to the knowledge of the member that Abdul Mateen had expired. And DW1 has also stated in her statement that Abdul Mateen has expired, Lordship. Page 16 and 35.
Who expired?
Abdul Mateen, Lordship, the father of the petitioners.
In this order where it is mentioned, page 57 order where it is mentioned,
Operative part is at page 60, Lordship,
page
60,
60.
point 4, para 4.
No, where we have stated that he has expired.
Oh, Lordship, I had stated in my WS, Lordship, page 16, para 4, page 16, Lordship. But the husband of OP number 1 and the deceased father of OP number 228, namely late Abdul Mateen, who already expired on 22 August 2015.
Yeah, reading where, please tell us the page, otherwise
16, Lordship.
16.
Page 16. Page 16, para 4, Lordship.
Which paragraph?
Para 4, Lordship, last para. Point 4, last para.
No, your prayer cannot be exceeded to. Your father was declared to be a foreigner.
Yes, the Lordship,
So
but
you, the reference was not on 2 to 9, so they were against them, it was dropped.
Lordship, my case is that Abdul Mateen did not contest the case since he has expired on 2015.
That's
And-
for you to substitute yourself.
And moreover, when they had filed
Your
a
father was
petition-
declared, if there is no challenge, your father remains declared to be a foreigner. You can't do anything about it.
Lordship, when they had appeared before this honorable court, they were also silent at that time that their father had expired. But in my written statement and even in the OP, DW1, page 35, Lordship,
You see, your case is horribly affected by principles of res judicata. You came to court earlier. Earlier, you did not agitate it. You can't come to court every time and then make one prayer after the other. That in the first prayer, it is to drop 2 to 9. Second prayer would be a second petition to say that your father expired. This is not how you present
But
your.
Lordship, in my written statement, I had stated that my father had expired, Lordship. Even in my DW statement also, I had stated.
If the reference would still be answered.
But,
This is not a decree passed against a dead person to be a nullity.
but Lordship, since Abdul Mateen has not contested the case, declaring him to be a foreigner, Lordship.
Correct. Absolutely right.
Lordship, an opportunity.
You see, you were there in the, before the tribunal. You did not substitute yourself and you said that you came to this court and said that the proceeding is not against them. So you were exonerated. But the fact remains that your father was declared to be a foreigner. Reference has to be answered.
But Lordship, we have not considered the fact that my father had expired, Lordship.
It will not, no one will do it. The reference is whether this person is a foreigner or not. So even a dead person can be declared to be a foreigner.
Lordship, then a date may be fixed. Let my senior counsel come, Lordship.
The reference has to be answered. And this point you should have taken earlier, then we would have dealt with the matter at that point of time. In the first writ petition, you allowed your names to be exonerated. This time, that time you did not agitate, or we would have taken that itself.
Lordship, that was a mistake of the earlier council also.
We don't know. If that be so, then we'll recall the earlier order. If it is vitiated by error of fact,
But Lordship, this citizen
Lordship, the petition was filed after the impugned opinion was passed. So
Yeah,
that means that with suppression of facts, they had come before this court.
we don't say that. We are saying that it is, if the reference was only against one, not against the other, we adopt it. That time you did not agitate. It will be barred by constructive rejudicata.
Lordship, this petitioners are illiterate person, they don't understand the procedure of law, Lordship. Later on, when they
Lawyer was
realized that-
illiterate.
One, they were,
The issue, the writ petitions are drafted by lawyers.
yes, Lordship, later on, when they realized, they came to us, Lordship.
Please don't blame the client. Or don't blame the lawyer. You can save the learned counsel and then say the petitioners were illiterate. You took a conscious decision to come here and then say that the writ petitions be exonerated. We accepted your contention, exonerated you. And when you see, it's a very specific observation at page 64. Resultantly, the said opinion dated 28/2/2019 shall only be operative against the limited to declaration of Mohammed Abdul Motin as foreigner post 25/3/1971.
Who had already
Once
passed.
give a declaration, then we can't touch it even the second writ petition. Your second writ petition is barred by principles of res
But
judicata.
Lordship, since Abdul Motin is not been represented, Lordship, an opportunity may be given because he had expired. Nobody represented him.
There's a principle that if somebody is expired, then you will have to substitute yourself. That you did not do. That will dismiss the matter.
But
It's
Lordship,
not be maintainable.
this writ petition is for that only, Lordship.
We can't do anything.
Lordship, then a date may be fixed, Lordship.
You can't do that. Why you permit us to disclose our mind and then say that no, we will not do it.
Lordship,
If you
because.
want to take an adjournment in the morning, we did not stop you from taking an adjournment. You do it and then you say that no, when you feel that the pulse of the pulse is adverse, then you say that no. That won't be permitted.
But since Abdul.
It would reduce the proceedings to be just a proceeding where you can come, touch, go, and then again come back. Sorry, that we are not permitting.
Lordship, I would like to withdraw the matter, Lordship.
Pardon me?
I would like to withdraw the matter, Lordship. Because if my senior counsel is also not there, Lordship, or a short date may be fixed.
You want to withdraw the writ petition?
Yes, your Lordship. With the direction, Lordship, with the liberty,
No liberty. Absolutely no liberty. We pass on order on merit because you see, that's not permissible. You argue the matter, we deliberate, and then you say that you want an adjournment. That's not permissible. You should not have opened it up at all. It's something we can't be lenient with. If we do for you, then there'll be 100 more lawyers who are waiting to do that.
but Lordship.
Walk till the end and then walk over. That's not the
Lordship,
way.
this person could not even represent the case, Lordship.
We
and
can't help it.
Another opportunity will be given, Lordship, to
We'll deal with that.
substitute his son's Lordship to
Hmm?
the sons of this is Abdul Motin may be
You
substituted.
see, when the earlier writ petition was filed, he was son.
Lordship, that was.
Then that he was never assailed, and when he gave a declaration, now you are filing a second writ petition. Second writ petition to do what? to take away the observations made in,
First read.
in the first writ petition at declaration given in paragraph 13, is it permissible to issue writ against oneself? Can I issue a writ on me and then say that this order be set aside?
But my submission is only limited that Lordship Abdul Mateen has expired. He has not contested it here.
This presumption will be barred by constructive res judicata, because you will be deemed to be subject, you are the legal heir. Is it open to you to now say disown your father and then say that no, I want to say that the father was deceased at that time and the declaration could not have been given? Reference is whether this person is a foreigner or not. You are bound by that. And there are consequences attached to it. If a person dies with a declaration that he is a foreigner,
And Lordship, I would like to withdraw the case, Lordship.
heard Miss A. Hussain on counsel for the petitioner and so for the respondents. Next, in view of the nature of prayer made in the writ petition, on a query of the court as to whether the prayer made would operate contrary to paragraph 13 of the order dated 11/3/2025 passed by this court in WPC 5555 of 2019. The counsel for the petitioner seeks to withdraw this writ petition. Prayer is allowed. The matter stands dismissed on withdrawal.
Upgraded item 27.
Yes, what is the idea for?
Met with your Lordship. The order earlier passed in the writ petition, I have annexed the lecture 1, page 8, Lordship. Page 8, your Lordship will find the police station against the writ petitioner's name was shown as Bullock.
It can be permitted, Ms. Verma?
Yes, Lord.
Heard. This is R. Chaudhary, and senior counsel assisted by Ms. S. C. Murtaza and counsel for the applicant. Also heard so and so for the respondents. Next, madam. The learned senior counsel for the petitioner has submitted that the residence of the petitioners is within the jurisdiction of Tamar Hat, TAMARHAT police station. But due to inadvertence, in the court title of WPC 3658 of 2026, the police station Golakganj, GOLAKGANG has been mentioned in the cost title. Full stop. Accordingly, it is submitted that though this court had granted interim bail by order dated 17/7/2026 in WPC 3658 of 2026, the bail could not be availed because of the error in the description of the police station. Next, madam. Having heard the learned standing counsel for the water and FT matters, the prayer is allowed, thereby allowing substitution of PS Golakganj, GOLAK, GNG, appearing in the cause title in respect of the petitioner, to be substituted as PS Tamara, TAMARHAT. Next one. In view of the nature of amendment being allowed, comma, time granted to the petitioner to take bail is extended for a further period of 10 days from the date of this order. Stop. Next para, accordingly, comma, it is provided that in the event the petitioner appears before the superintendent of police within bracket border, bracket close within a period of 10 days from the date of this order, comma, the said authority shall accept the bail bond in terms of directions contained in the order dated 17/7/2026, passed in WBC 3658/2026. And in the writ petition, it is just one more line. This order shall be read together with order dated, that earlier order, 17/7/2026, passed in WBC so and so. This application stands disposed of. Then in the writ petition, you say both sides are represented. In view of the order passed today in IA Civil 2642/2026, comma, the learned counsel for the petitioner shall submit a amended cause title to the AOJ, FT section for being incorporated in the writ petition and for consequential correction in the data of the CIS system. Next para. The records have come.
No, Lordship,
As the records of the tribunal is received, comma, this is the matter on, give a date after 2 weeks. No, it's not required. Give a date after 2 weeks.
August 26.
Published, Lordship.
Upgraded item 30.
My lord, in this case, earlier, my lord, the petitioner was granted bail by this honorable High Court, that may be seen page 7.
In 2017,
Yes, matter of 2017.
then
Now, bail was granted, and according to the conditions of the bail, I appeared, I wanted bail from the SP, Dorang. Then again another order was passed, that may be seen page 10. On 1/5/24, that the petitioner will appear before the SP, and the SP will take the this eye, finger express, etc., etc. So this order, he was regularly appearing before the officer as was directed by the OC, or before the officer who was deputed. But as for second order, he did not think that I shall have to again go on bail, because earlier he has been granted bail and he was appearing as directed. So this, as the order is in force till today, so I will appear, but some time may be granted.
We are in 26.
Yes, that is correct.
No,
But I was
does it
appearing before the
justify
petition server.
Does it justify the petitioner's conduct, lordship?
No, I have appeared. I have made a statement, categorical statement in my petition. Actually, on my appearance, the officer says that you go and take some extension. Can you see para 3 of my petition?
No, no, your petition is without any supporting documents. In the earlier order of 10/11/17, you were not directed to appear before the police. If you
No,
appear, then-
Board did not direct, but the officer normally direct that after 15 days or 1 month you
no,
come.
no, no, never.
No, lordship.
Never.
We don't have this practice.
That practice is, we have come to know for the
Unless
first
the
time.
persons are appearing before the officer after 1 month or 15 days as directed. In each of the cases, though there is no direction from the law, but they put some direction that every month you come, as the case may be. Sometimes 15 days, 1 month or 2 months. So I was appearing. And as I was already on bail, so I did not think that that is again to be done. Kindly see page 4 para 3, I have stated on these things. The applicant wishes to state that though he came to know about the order dated 1/5/24 earlier, but he did not come on bail as he was regularly appearing before the respondent opposite with number 5, that is the officer in charge, Jhula police station, as he was directed by the state authority at the time of granting bail as per Honorable High Court's earlier order. Is it not I am escaping? I appeared. I was appearing. But when this matter came to the knowledge of the OC,
That is
officer-
some private arrangement, but we can't take cognizance of that. Very difficult.
no, however, I will appear. Kindly grant me some time.
Lordship, I have a small submission. Since the matter is of 2017, Lordship may fix it up for hearing and take it up for final hearing, Lordship, next week. TCR is also before Lordship.
My lord, there was no reason why I shall not appear, because I am on bail.
It is okay, Lordship.
Actually, there is
Send the
some
time.
misunderstanding.
24 order after 2 years is coming before this court, and this matter is already pending from 2000.
It's okay, we'll take up for hearing, but we
Yes.
extend the time for bail because it can't be taken into custody. We already granted bail.
Lordship may extend the time and at the same time fix this matter for hearing, Lordship. Fixed date may be given.
But Mr. M.U. Mandal, learned counsel, M.U. Mahmood, learned counsel for the petitioner and so for the applicant. And so for the respondents, next fellow. The applicant was granted bail by order dated 10/11/2017, passed in WPC 6750 of 2017. Thereafter by order dated 1/5/2024, passed in said petition, the applicant was directed to appear before the Superintendent of Police Border, Dharang at Mangalday, on or before 22/5/2024. During the office hours, along with the certified copy of the order and certain further directions were issued for procedure to be adopted by the state authority on appearance of the petitioner, of the applicant. Next slide. By the said order, it was also directed that on failure of the applicant to comply with the aforesaid directions, the bail granted to him would stand automatically vacated. Next, learned counsel for the applicant has submitted that due to inadvertence, the applicant could not appear before the Superintendent of Police border, Dhawan, Mangalday, within the time allowed. Accordingly, prepared for by filing this interrogatory application for the applicant seeks extension of time to appear and take to extension time to appear before the said authority. Next, the learned standing counsel for the water and FT matters opposed the prayer on the ground that the petitioner has approached the court after 2 years. Next paragraph. Having considered that the applicant was granted bail by order dated 10/11/2017, considering the submissions, considering projections made in this interrogatory application, the court is inclined to extend the time for the applicant to appear before the Superintendent of Police border, Dhawan, Mangalday, within the extended time of 10 days from the date of the order. In the event the applicant appears before the Superintendent of Police border, Dhawan, Mangalday, within the extended time, the said authority shall take appropriate steps as required by the said order dated 1/5/2024, passed in WBC 6750 of 2017. Next para. Failure on part of the applicant to comply with the directions contained in the order, the effect of paragraph 13 of the order dated 1/5/2024, passed in WBC 6750 of 2017 would stand revived. Next para. The application stands. We have said that, excuse me, we have said that he will appear before the SP border. Just add there and produce a certified copy of the order. Just reconstruct that. He will appear before the SP border and then produce a certified copy, and then time will be extended. Yes. ISN is disposed of, and in the writ petition you say both sides are represented. As the records are received, list the matter for hearing on. No, you see that issue rule returnable forthwith without requiring any steps to be taken. Next, list the matter for hearing on. Give it after 2 weeks.
Obliged, highly obliged.
Sorry, I had some administrative works. Yes.
Last occasion, in item 1, 2, 3, 4, for analogous method losses. On last occasion, I was directed to file affidavit. So we have filed affidavit in 2 and 3 by my colleague losses. But both the respondent number 2, the earlier director has been expired. And the respondent 1 also retired 4 years back. So losses to file the affidavit on oath losses. They have to either include the present director or losses, or losses may give a specific direction to the present director to file the affidavit losses.
You see, it's a contempt.
Yes, losses.
In the contempt, it is for the person to purge of his contempt.
but he is expired with respondent number two in item number one.
Respondent is expired.
Yes, item number one, respondent number one, retired 4 years back. And respondent number two, the director, earlier director, he expired already, Lordship. That is the difficulty we are also
But
facing, Lord.
that has not been brought on record. Is the fact of death brought on record?
No.
No.
Earlier, I have verbally, I think,
No, you see, in a contempt proceeding, the contempt must abate if the
Yes.
person has died.
yes.
Because contempt petition, it can't be, nobody can be substituted.
Then I have to collect the death certificate to substantiate.
Not that, but the director can give a affidavit and tell us that this person,
No.
according to their records, have died.
The present
So
director.
then those people will have to be abated, and then the successors will have to be found out who's the person who's the next in line for the
Yes.
contempt.
Yes. But in item number two, the earlier director was substituted, so present director has already filed the affidavit. And three also they have filed the affidavit. And item number four, the earlier director still remains also, he has expired lawsuit.
You see, so far as considering your prayer is concerned,
Yes.
it's not an objection by the court,
Yes, sir.
but there's a technical difficulty. A does a contempt,
Yes.
he is alleged of doing a contempt. B files an affidavit. Now, if you have to examine this, how will you do it? Because I'll have to take responsibility of the orders I am passing.
Yes.
In a contempt, please tell me if it would be appropriate to, let us say that we
They
arrive at
can
a,
implement lawsuit the present director.
no, that's one part, but you
Yes.
made that clear. That's why we are asking, will it be appropriate without substitution to pass an order permitting A to file affidavit
Yes,
on behalf of B,
That is also, yes.
and B, normally it should have been awaited. Can we extend our jurisdiction to that? That's the issue. And therefore, you'll have to tell us, if you file an affidavit, how should we proceed?
Easiest option is to let my learned senior friend file an impleading. I will take the notice lawsuit, immediately lawsuit will allow.
But you'll have to tell us that so and so is expired. We'll take your,
Yes, lawsuit that earlier SK, he has expired lawsuit.
just a moment.
And director is the appointing authority lawsuit. And respondent one, he has retired long back lawsuit.
Those orders are not here. But Mr. P.P. Barwar, and counsel for the petitioners, who has submitted that despite this contempt petition being filed on 8/6/2016, the judgment and order dated 17/12/2015 passed in WPC 3470/2015 remains remains uncomplied with. Uncomplied or has not yet been complied. Next para. Mr. SMT Chisti, learned counsel for the respondents, has submitted that he has been instructed that the respondent number one has superannuated long back.
Yes,
Do you have the estimated year? No.
lawsuit.
Do you have the estimated year?
Around 3 years back lawsuit.
Superintendent about 3 years back, but he does not have the exact date. Stop. It is also submitted that the respondent number two, give the name of number one, Pritam Saikia, Preeton, Sri Pritam Saikia, And number two is Sri Sanjeev, SANJIB, Sanjeev Kumar Bhune. The respondent number two has expired. He expired about 4-5 years back.
No, Lordship, around 2 years back, one and
Years
a half
back.
and 2 years back. That I forgot, Lordship.
Okay, about more than a year back. Next para. Accordingly, comma, the learned counsel for the petitioner shall take note of the same in a said statement. Full stop. Next para, it will be open to the petitioners to put the new incumbents to notice. And if the order remains, if the said order remains not complied with, comma, the applicants may plead the new incumbents.
Yeah.
Next para. As paid for by learned counsel for the petitioners, comma, list after. Mr. Barua, after how much time? List after?
Yes.
I think 4 weeks will be better because you'll have to give notice.
Yes.
To put the order to give them a notice of compliance of the order. List.
Item no 4.
These are very old matters, give fixed dates. After 4 weeks, 4 or 5 weeks, give a fixed date. And then
Item 4 is the same, Lordship.
Order is different.
Order is different, but one.
No, one by one, in item 2, what is to be
Item
done?
2, Lordship, we have filed our affidavit, Lordship.
We have filed already reply.
You have filed a reply, so it is ready for hearing.
Ready for hearing.
We have filed reply. And
Okay, in item 2 is
we have ready to file reply regarding item number 3.
one by one.
One by one.
We can't jumble up
Item 2,
everything.
Lordship, we have filed affidavit, they have filed reply. So it is ready for hearing.
In item 2, you say that both sides are represented. Next, it has been submitted at the bar that pleadings have been exchanged and the matter is ready for hearing. Full stop. Now, please tell me, will be there any difficulty if we segregate this and take it up for hearing?
Yes, no difficulty, Lordship.
No difficulty.
No difficulty.
Okay. As per the submissions made at the bar, comma, though this matter is tracked with other connected contempt petitions, comma, but the learned appearing counsel for the parties have no objection if this matter is segregated and taken up for final consideration. Full stop. Accordingly, matter stands adjourned today. List this matter separately on, give a date after 2 weeks. Yes. List on so and so. For the consideration after 2 weeks. He'll give it just number 2. Then now number 3.
Three, we have filed our affidavit, Lordship. They want to file a reply.
Okay.
So both the item can be taken together and listed on the same day, Lordship.
Okay. Item 3. Both sides are represented. On the prayer made by the learned counsel for the petitioner. How much time?
2 weeks, my lord. That may be fixed, my lord.
2 weeks time is granted to the petitioner to file affidavit in reply. Full stop. List on. The affidavit shall be filed at least 2 days prior to the next day of listing. List on, give it same day on item 2. Okay. Now item 4.
4, they have to take similar to item number 1, Lordship. They have to take the steps.
Okay.
Only order is different. Same order may be
Okay. Item 4, it will be same as item number 1. Non-compliance of order dated 19/1/2017, passed in WBC 2996/2015. Same, becomes expired and Sanjeev Kumar Bhuiyan.
Item 1 and 4, 9th of September. Item 2 and 3, 24th August.
Oh, just a moment. In item 3, we also make the same statement, the learned appearing counsel for the uh, in these matters have no objection if the matter is segregated and taken up for final consideration separately. List on service, no? Same order. Okay. Yes, item 5.
Yes, 5 lawsuits, we have already provisionalized the service of the petitioner lawsuit. This is the compliance order issued by the director. Lawsuit may kindly peruse this one.
Does Mr. Saikia know it?
It was provisionalization order.
Mr. Saikia, you will have to withdraw it.
Yes, my lord. It will be closed now.
Heard Mr. R.C. Saikia and senior counsel assisted by Mr.
Vinod Baskur.
Vinod Basford and counsel for the petitioner, as well as Mr. S.M.T. Chistil and counsel appearing for both the respondents. How many respondents are there?
Here are total lawsuits, 5 respondents lawsuits. I'm for 2, 4, and 5 lawsuits.
Respondents were 2, 4, and 5. You have abundant 1 and
1 is the lordship, 1 also I can represent, yes, commissioner and secretary, yes. 1, 2, 4, and 5.
for all the respondents. For the respondents. Next para. The learned counsel for the respondents has produced a copy of order number so and so, dated 6/8/2026. Whereby the service of the petitioner, namely, Sipra Mitra, ELT within bracket tutor of Tengapara, TENGAPARA High School within bracket Bengali medium bracket closed, Kokrajhar, has been provincialized
With effect from 25/9/25 lawsuit.
with effect from 25/1/2025.
09 lawsuit, 25/09.
Where is that?
In the last column, look it.
Okay.
That are effect.
25/9/2025. Full stop. He has also produced the instructions dated 6/8/2026. Next para. In view of the hearing before referred order dated 6/8/2026, upon instructions from the learned counsel for the petitioner, the senior counsel for the petitioner submits that the matter may be closed on satisfaction. Accordingly, this contempt petition stands closed on Satisfaction.
Oblige you.
Item 6.
This pertains to the non-payment of the retirement benefit, my lord. There is, petitioners were the employees of Assam State Transport Corporation, my lord. We have, yet to pay this man, Mr. Das. We are yet to pay 3,72,070,000, my lord. 3,70,523 rupees. My lord, I am being, informed
No,
by
you'll
the.
have to file an affidavit as to who will bear the interest for the delay. You file an
My
affidavit.
lord, actually, what happened, this money is coming from the government because they,
Just tell us who will pay the interest. You can name the, you can disclose the name of the Commissioner of Finance who is responsible for the delay. Just tell us. File an affidavit who
My
is
lord,
going to
my-
pay their,
my lord, we are filing an affidavit immediately.
do it, because otherwise the payment will never come. Retirement benefit is the last priority. And we'll require your personal presence of all these people. They have, their personal appearance has not been exempted. This Anand Prakash Tiwari is still the managing director.
No, my lord, he has gone, my lord. Now, the new managing director has taken charge last year only.
Why this was not brought to the notice earlier?
Well, I personally will not submitted before the court and the coordinate bench, my lord, that this man is no longer there. Even he's not even in the state cadre now. He has left. They have not implemented the present incumbent.
Please be sure when you are making submissions. It'll make, you'll land some at difficulty, 22,526, the last forward. Look at the order previous to the first order sheet. Yes, please read. Please read, will refresh our memory because. No, please read loudly.
Well, this order dated 22/5/2026.
Yes.
Mr. So-and-so, land counsel for the petitioner is present. Mr. Y.N. Mamanto, land counsel appearing from behalf of Mr. Sumar, land advocate, submits that steps have been taken to make payments to petitioner number 1, 2, and 3. The land counsel has submitted that while attempts are being made to release the entire amount in favor of petitioner number 2, due to paucity of fund, part payments are also being sought to be made in respect of 1 and 3. Accordingly, pays for some time to enable the respondents to make the payments. This is the material concern, so it is accrued to respondents to comply with the orders.
Therefore, you see, once you are holding the brief for respondent number 1, that's the submission made. It binds your client still now.
No, look, our attempt
No,
was.
we have shown it. This is not a question of attempt. Please be very clear. If they have to impede, we'll do it.
Well,
These are contempt petitions of
well, no need,
2020.
Milord, we have to pay. There is no second thought of this. The only difficulty is these funds are not coming. That
No,
we
for
are.
the retired person, funds will never come. Where we have seen the urgency of the state government to make payment to a retired person? Any case you know of
No.
in the High Court?
Correct, very
Then-
correct, very correct.
Doesn't impress us. You disclose the name of the current incumbent, we'll record it and we'll ask them to be implemented. You should be more vigilant than the respondents. You are wanting money. This man is now how many years old? 64 years when the petition was filed in 2020. We are in 60, so they are now 70.
70.
You will have to be vigilant about it. They have superannuated the writ petitions are of 2018. both sides are represented. Mr. Sorry, Dr. A. Samar, learned counsel for the respondent, has submitted that the respondent, namely Sri Anand Prakash Tiwari, was the erstwhile managing director of the ASPC, he is superannuated.
No, he has left the state cadre, he has gone to
Okay, he
different.
has left the state cadre and he is presently posted outside the state. Full stop. Next, but accordingly, the next para, this contempt petition was filed on 7/3/2020 and notice of the contempt proceeding was issued by order dated 13/3/2020. Though the personal, though there is no order of this court exempting personal appearance, no affidavit has been filed in the matter. Full stop. It may be mentioned that the case of the petitioners is that they had superannuated as far back as in the year 2014, TO2 2018. And accordingly, owing to non-payment of their retirement dues, the petitioners had approached this court by filing separate rate petitions, which were all taken together, and by an order dated 22/7/2019, directions were issued to the ASTC to pay the retirement dues of all the employees of ASTC who had superannuated up to 31/3/2018 within 31/12/2019, CPF dues to be paid within 31/8/2019 and other retirement dues to be paid within 31/12/2019. Stop. In respect of those employees who had superannuated from 1/4/2018 till 31/3/2019, their retirement dues was to be cleared within 31/3/2020. And thereafter, retirement dues of employees superannuating after 1/4/2019 was ordered to be paid. And the managing director, ASTC, was directed to ensure compliance of the court's order. Full stop. Next para. Thus, if the petitioners have superannuated between 2014 to 2018, their present age would be about how many years? 2014 plus 12. Okay, this is retirement age is how much? 58 or 60?
60.
So 60 plus 12 is 72 to 68 years respectively. Full stop. Therefore, at the petitioners have been deprived of their retirement dues for long time. Next para. Therefore, comma, taking serious note of the failure on part of the respondent to file any affidavit, comma, the respondent, namely Sri Anand Prakash Tiwari, is hereby summoned to appear before this court in person on, give a date after 4 weeks, failing which he is put to notice that bailable warrant would be issued for his appearance. Next paragraph. In view of the statement made by the learned counsel for the respondent that the sole respondent has since left ASTC, the learned counsel for the petitioner will be required to put the new incumbent to notice of compliance of the order dated 22/7/2019, passed in WPC 39 of 2019 and connected writ petitions. And if the order is still not complied with, it would be open to the petitioners to implead the new incumbents. Next paragraph. Date of appearance after 3 weeks. Give a date after 3 weeks. The so of appearance of the respondent contender.
August.
Yes, item 7. Okay.
The petitioner, he is the son of the retired father, Dr. A.K. Desmukh. He was the retired head of the Department of Silchar Medical College. Here already judgment has been passed regarding during his lifetime he did not receive a single amount of pension. He died in 2000, and after that, my lord, the present petitioner, he had filed the writ petition, and ultimately this has been disposed of 2014. Has subsequently review petition was also filed that has been disposed of 2019. Now, my lord, before filing the WPC case, now certain amounts the pensionary benefits have been received. But my lord, 12% interest, now they have sanctioned the amount, my lord. They have sanctioned the amount, but several days have been.
Yes, Lordship, here the budget is now available. There has been some delay, Lordship. Now, from the.
This doctor was a very renowned doctor of his times.
Yes, Lordship.
He's not got pension, died before that.
Lordship, some amount, now the issue is, Lordship, the petitioner is in Pondicherry. So there was some communication gap from our end. There was some, Lordship, there was some difficulty.
No, but tell us who is the officer responsible to make payment of interest?
No, Lordship, here, that interest has been calculated. Lordship, I am appearing for, none of the respondents are holding any post right now, Lordship, but I am still following it up and I am getting the necessary information for making the necessary payment. Now, as per this communication, Lordship, the budget is available. There are some technical issues because of which will be released. I'll pray for my Lordship to grant us 2 weeks time. I'm only appearing for respondent number 2, Lordship, yes, in the year 2020 itself. So Lordship will grant me 3 weeks time. In that meantime, Lordship will make an observation of the payment.
No, but who's appearing for the respondents? Nobody is appearing for any of the respondents?
Lordship, since I am a standing counsel, I have been just assisting the court regarding the other.
No, that is something we appreciate, but there must be someone who is holding the brief for the respondents.
Perhaps if the steps have been completed, I'm aware, because none of at the time when the steps were taken, whether they were holding that post or whether notice was served upon them, I'm not aware of it. I'm only representing respondent number 2. He had retired in the year 2020, but he had filed the affidavit, Lordship, stating the same in the contempt proceeding.
As per last order also 12/6/2026. They have.
No, but please be sure of what you are saying.
Lordship, yes.
The because this court in one of the orders have recorded your presence as the counsel for respondent numbers 2 to 6.
Lordship, that will be in my wakalatnama has been filed for only respondent number 2. Perhaps I was appearing, that is why, and I've been assisting the court because Lordship, I'm getting information from the government also.
This is 2, 3.
Although I'm not representing them, but being a standing counsel, Lordship, that is, I was just assisting the court, Lordship. Maybe,
Just a moment.
yes, sir.
Actually, what was actually he is suffering a lot, my lord.
Yes, Lordship, that I'm not. We are trying to expedite the process, Lordship.
The amount has been sanctioned in 2024, my lord. But ultimately,
As per this, Mr. Devajit Saike appeared along with you for respondent number 2. Again,
Yes, respondent number 2.
Mr. Devajit Saike, senior counsel, along with Mr. D.P. Bora and Buddhadeep Bora, entered appearance for respondent number 6.
Respondent number
So therefore, notice steps is required to be taken on 2, 3, and 6.
Lordship, the wakalatnama might be filed, maybe I
We
think.
don't know, that is something recorded in our office note.
Lordship,
So it has to be correct, because otherwise the appearance would not be recorded in the manner.
maybe for respondent number 6, I'm not aware, Lordship. Maybe DP Bora appear.
Just take note, inform them otherwise, because if appearance is recorded and nobody is there, then we have no alternative but to summon him for personal appearance.
but my lord, initially Mr. B. Google also appeared. B. Google appeared on 2, 4, 6.
That's what we are saying. But the steps on the other respondents is not complete.
Yes.
Why you don't pursue these matters?
My learned friend here.
Now, Lordship, that is why I was asked to assist the court, because no steps were being taken at that appropriate time, Lordship. Now,
2 and 6.
Office now.
2 and 6. 2 and 6 always 25.
No, steps is in your own way. Whether he assists us or not, there's a different thing, but you have to. No notice was issued on respondent number 1. The principal secretary, no notice was issued.
Response number 3.
No, you have to take it. There's no service report.
2, 3, and 6.
Heard Mr. S. Sharma and counsel for the petitioner, who has stated that the judgment and order dated 11/12/2014 passed in WPC 4676/2008 has not yet been complied with. First of the case of the petitioner is that his father was a former professor and head of the Department of Surgery, Silchar Medical College and Hospital, Assam, who had superannuated from service on 12/8/1985 after rendering more than 26 years of service. Full stop. The however, the pensionary benefits were not extended in due time, and in the meanwhile, his father, namely, Dr. A. K. Deshmukh, had expired on 18/5/2000 without receipt of any pension or pensionary benefits. Full stop. Accordingly, the petitioner, the petitioner number one, the petitioner along with his brother filed a writ petition being WBC 4676 of 2008, where the order dated 11/12/2014, Reverend was passed. Full stop. The said order has attained finality, and despite 12 years of the said order, the pensionary benefits have not yet gone to the legal representatives of the deceased doctor. Next paragraph. On receipt of notice, only the respondent numbers 2 and you just say by this court by order dated 15/2/2022, issued notice only on respondent numbers 2 to 6 and no, notice only on respondent number 2, 3 and 6. Full stop. While Mr. A. Chalia, learned counsel, enters appearance for respondent number 2 and Mr. P.P. Bora and Mr. B. Gogoi, learned counsel, have appeared for respondent number 6 along with the senior counsel. However, notice on respondent number 3 is yet to be served. Next para. Accordingly, the petitioner shall take steps within 3 working days for service of notice on respondent number 3 by speed post to the postal. The learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the next date of listing. Whether the respondent number 3 is in the same place or he has been transferred or superannuated.
Lordship, he is retired.
Okay, then don't write that. You say at this stage the at this stage the learned counsel for respondent number 2 has submitted that as per his information, the respondent number 3 has also retired. Full stop. Next paragraph. Therefore, comma. The learned counsel for the petitioner shall ascertain the correct address of the respondent number 3. Full stop. If so advised, the petitioner may put the new incumbent to notice of compliance of the order dated 11/12/2014 passed by this court. And if the order is still not complied with, comma, liberty is granted to impede the current incumbents. Next paragraph. Accordingly, awaiting appropriate steps on respondent number 3, comma, the matter stands adjourned today. Next paragraph. Yeah, we combine these two paragraphs together. The we have written for respondent number 3. Now you also write for respondent number 2. 2 and 3 are superannuated. Two is also superannuated, so you have to take steps. He's appearing is a different matter, but you have to be vigilant.
But respondent number 6 is the principal of the Silchar Medical College. He was liable to pay the arrear salary, and arrear salary is along with 12% interest.
Mr. Sharma, we have not applied our mind. We are just putting you to notice that number 2 has superannuated. What is the consequences? We have not applied our mind. I just have a bad habit of flipping papers, and when I read the affidavit of the respondent number 2, there is a clear-cut statement made therein. This affidavit was filed in 2016. In 2016, he has disclosed that the respondent number 2 has left service. You should have amended it by now. When I'm looking at our old file, I'm looking at all the documents, and therefore I find out from the affidavit filed on, filed on 27/6/2023.
Just one more.
Next paragraph.
Regarding this amount has been sanctioned in 2024. 24, there is an order, madam. 24, I want to make it clear.
Please try to understand the gravity of what we are saying. Mr. Sharma,
Yes.
after this 2 and 3 have superannuated, can they do anything in the government? They can only respond to the contempt which has occurred when they were in office. Contempt is not a jurisdiction to pass directions for the payment to be made. We are just enforcing it because of our powers to call the persons and to see compliance. But what happens if a person has superannuated? Please tell us, how do we derive power to make him any direction that please bring money from the government and pay it to him? You don't understand that. Mr. Shalia is saying that he is not making statement as a counsel for respondent number 2. He is as a departmental counsel telling us that this has been sanctioned. But can we enforce it? The statement made by Mr. Shalia at the bar, can you enforce that? The answer would be no. He is assisting us. That's why we don't say anything, because he is assisting us, in fact.
Yes, yes, my lord.
He has filed an affidavit saying that the name of respondent to be struck off, as he is no longer there in the office. Yet he is assisting the court in bringing out the documents. But show us a way where we can enforce the order. Respondent number 2 and 3 can't be told to go to the government and bring money. You don't take steps for implement. Next paragraph. The Learned Counsel for Respondent number 2 submits that not in the capacity as the counsel for respondent number 2, but in his capacity as the standing counsel for the medical education department, he has received instructions in form of a letter dated, in form of a letter under memo number, this one, memo number so and so, memo number so and so, dated so and so, 6/8/2026. Stop it. It is deemed appropriate to quote the contents of the said communication. This one. You don't need to write the names and all, only that operative part. Instructions of 6/8/2026 by the Secretary to the Government of Assam, Medical Education and Research Department. We deem it appropriate to quote it below. Next paragraph. Accordingly, awaiting steps, required steps as indicated above to be taken by the petitioner, the matter stands adjourned. Next paragraph. List on. When is the last date given? Same date. 24? No. 21/8. No, I do not want to know. Next date, last के दिन है.
Last 31/8 items.
31/8. No, in the last order will be directed steps to be taken for implement and all that matter. So 9th of September. Mr. Sharma, you have to put them to notice and then make an prayer for their implement.
My lord, I have to implement them again.
You have to do it. You know better. You see, I have left practice. I can't say what to do. You have to tell us what you want to do.
Outside, I'm just submitting because
You'll have to do
they
it.
have already sanctioned the amount.
You'll have to put. No,
They are going to release the amount, my lord.
Mr. Sharma, it is your choice.
Yes, sir.
But we have to pass orders in a manner which is so desired, and therefore, in accordance with law, we are passing an order. It is dependent on you. We can't advise.
My lord, he will be directed to submit
Acha,
present income.
This is made a part of record.
My learned counsel may be directed to submit the present income.
In contempt. No, I would be last man to pass such
I
order.
will not be in position.
I am the last man to pass such an order, but Mr. Sali has taken note of it. He will do something, but it's very difficult. That's what we are saying.
Already in a very pathetic condition. He lost, his wife died, he died, his eldest son died. He is the only son now. Illegally, he is entitled to receive this pay.
He can't do anything.
paid, lordship. Very pathetic condition.
He can't do anything. एक सेक्शन में करना प्रॉब्लम करो कि हमारा ऑर्डर और माजर ताकि मतलब हमारी से करो नहीं बस हाई लो এইটো মানে নোটশ্বিটৰ লগতে এই অৰ্ডাৰ এইবিলাক আহি গৈছে এইটো আকৌ নোটশ্বিট অসুবিধা হয় চাবৰ কাৰণে এইখন ইয়াতে লগাই দিব হা নোটশ্বিটটো বেলেগ কৰাই দিব সেইটো মান্থলি নোট ছেকশ্যনত Here's item 8.
Non-compliance of the order dated measure 23/11/2021. Case minus 47 and 48. Paragraph number 8, minus 47, page 47, paragraph 8.
What has happened to the appeal which has been filed?
Yes, my lord, appeal is,
lord,
appeal is fixed on, my lord, 22/9, my lord.
In
Text
condemnation,
it is fixed.
delay condemnation petition notice was served, we have appeared, and we have to.
But there is no stay.
Stay is not there.
No stay is
stay. The
there.
next date is 22/9/2020.
No, but if stay is not there, you have to comply with.
My lord.
My lord, kindly, after 22/9, my lord, kindly fix the date, my lord.
No, no, but you see, it's a contempt jurisdiction.
Yes.
Respondent number 5 has filed the affidavit. And what about others?
Yes, yes, sir.
Number 5 is the director's memo, border.
You can, have you filed your wakalatnama in the matter?
Yes, my lord, I have filed the number. Something like this.
Oh, yes,
Yes,
your signature is there.
yes, sir.
This is by respondent number 4.
Yes, my lord.
No others have filed.
What does it have?
Mr. K. Kalita, learned counsel for the petitioner, and Ms. A. Gayan, learned counsel for respondent number 4 are present. Full stop. This, as per the office note dated 24/8/2022, notices were issued on respondent numbers 1 to 6, full stop, however, the
Contempt is not given us, no?
How the service report is not available for the other respondents. Look for respondent numbers. 1, 2, 3. Right. 1, 2, 3.
Board has filed affidavit.
1, 2, 3, and 6. Next paragraph. Although an affidavit in opposition has been filed by respondent number 5, comma, to filed by Mr. Arkady Chaudhary, but his Vakaratnama is not found in the record. So accordingly, we direct Mr. Arkady Chaudhary, now counsel who was filed the affidavit in opposition, for the respondent number 5 to file his Vakaratnama prior to the Vakaratnama in respect of respondent number 5 prior to the next date of listing. Next paragraph. The petitioners shall take fresh steps within 3 working days for service of notice on the respondent numbers 1, 2, 3, and 6 by speed post with ED. Full stop. The learned counsel for the petitioner is at liberty to collect the postal receipt number and submit postal tax report prior to the next date of listing. Next paragraph. We take note of the fact that in the affidavit of respondent number 5, comma, at paragraph 9 thereof, it has been stated to the effect that in terms of the no objection issued by the Ministry of Finance and Ministry of Defense, comma, steps have been initiated to release the dues of the eligible 61 petitioners, and the process will be completed within a period of 3 to 4 months. And in order to expedite and expedite the documentation process, comma, is there any IA pending here? Thus, is there an IA here? No. Hmm?
There is no answer.
Just stop the one that 3 to 4 months. Next paragraph. In the SIT paragraph 9, for the respondent number 5 has further stated that in order to expedite and legitimate documentation process, modified copy of order is a mandate, and the honorable court may issue the same accordingly. To stop. In this regard, the respondent number 5 would be well advised that this court has already issued an appropriate direction while order dated 23/11/2021 passed in WPC 660, sorry, appropriate direction.
6603 of 2005.
No. Our High Court order. Order dated 18/2/2020 passed in WPC 1537/2015, which is required to be complied with. Therefore, it is not open to him, not open to respondent number 5 to make any prayer for any modification of the order by way of statement made in paragraph 9 of the affidavit in opposition. The
Review also filed, that is also closed.
no, we are not on that.
Yes,
I'm
yeah.
only sticking to whatever is there in the brief. You see, at the appropriate moment, you don't assess the court. That leads to the problems in the orders. The statement made in paragraph 9 is that the court shall pass orders, which has been wrongly noted in the order dated 17/7/2023, that the department has moved for modification of the order. That was never there. So you never checked it, and then the appropriate correction was never brought on record. Next paragraph. Next paragraph. Therefore, the order dated 23/11/2021 has to be complied with on has to be complied with as it stands. Next paragraph. In the meantime, the petitioners right, so steps were taken. The past orders for steps. Shall take steps for service of notice of respondents. The notice is made returnable on 9th September. The petition shall take step in 2 days for service of notice. No? Just get the date. Okay. Next paragraph. The respondents are put to notice that this is a case of continuing contempt, as the order dated 23/11/2021 has still not been complied with. Even after about 5 years. Next paragraph. Dispensation. You in the meantime find out if all the respondents are there, somebody would have superintended by then.
Yes.
Your contempt petition would be unnecessarily dragged. Find out if anybody has to be impleted, do the needful and then implement them. We'll not have time for other matters.
My lord, one item, my lord, next, item number 9.
Yes.
Item number 9, well, I will take 5 minutes only. It has not been complied with for last 2 years. Just one page, my lord, may I just show? Page 62. Page 62. These are grade 4 employees. They are not getting their area salaries and current salaries in terms of the order passed by this court. I have given the details of the non-payment, my lord, standing as on today.
I'll ask the matter to be listed day after on Wednesday because I have to rise. There's some
My lord,
administrative work. I have to be.
No, we are in great difficulties, my lord. The authorities are just not giving any response to the orders passed by the court. We are having a lot of problem, my lord. These are grade 4 employees. Court directed that you pay their current and career area salaries, and this officer has to be present in court, my lord. In terms of
Who's appearing for the respondents?
Mr. Dotto is there, and finance and urban. Respondent number 1, 3, and 4. They have to appear before the court. There is no exemption on them, my lord.
My lord, for the whether the
Unless-
appearance of the officers are required or not, your lordship can
No,
declare
you
it.
see, if the orders are not complied with, we can definitely do it because under the High Court rules.
This honorable court directed me to place certain papers, my lord, I am furnishing it.
Yes, my lord, the earlier
Let us
order of
see,
the
Mr.
court.
Das, Mr. Das, unless we see what is there, we can't.
My lord.
The appearance, my lord, for that after hearing us, my lord, just on the basis of his submission.
No. 2 years, my lord. 2 years order has not been complied
Mr.
with.
Datta,
My lord, I have explained it, what has
no,
happened to
Mr.
us.
Datta, under the High Court rules, the requirement is that unless by an order the appearance is dispensed with, he'll have to be present.
My lord, I am not on that, my lord. Now,
Just read that because I have to rise, Mr. Das, show it to us.
my lord, dear, what happened?
My lord,
The
Rule
Today I
5
won't
of the.
have time. Even
My lord, it's all right. Your lordship will fix it on Wednesday, my lord.
today we don't have time, that's why.
This, my lord,
Just a moment, Mr. Das.
yes. Rule 7 is there, my lord, of the contempt rules. Contempt of courts rules 1977, rule 7.
Mr. Datta,
my lord.
a strange thing has come to the mind. I'm just spelling it out. It may be appropriate, may not be appropriate. You'll excuse me for that. I was just reading few of the judgments of the past, where the Supreme Court has said, in case of what you call orders for maintenance under 125,
Yes,
that even if a person is unemployed,
right. He'll have to pay.
he'll have to pay. The able-bodied man will have to pay.
Right.
Now, the Silchar Silchar Municipal Corporation does not have money. You have to sell your assets, sell your head office.
My lord, in that case, what will be the ramification?
No, nobody's bothered.
No,
They will take a rented house.
Can look into that. I don't have
They'll
any.
take a rented house.
No, it's all right. Your lordship will pass the appropriate order.
No, we'll not pass
Malad-
it, because.
My lord, I have a reason to say, I have explained it, and my lord, I will
No,
explain.
you
I
file an
will pursue
affidavit.
it, lordship.
File an affidavit. Whatever you have to
Yes,
do in
we
the
shall
contempt,
file.
file it.
They have filed
It's
affidavit.
not
my
the
lord.
first time of its kind.
It is
my
the
lord.
finance department and
Suppose, my lord, if
Just
Mr.
a
Das, let me say something. It's not a TV show going on here. Now.
Don't make extra comments, Mr.
Don't-
Datta.
When I am submitting, why he should not do like that? He's also senior comes in, he should know how to.
I'm in his favor, my lord. I'm saying it is not the responsibility of the municipality alone. It is the responsibility of the finance and the urban bodies. This is what I'm saying.
No,
If
that's
he is
all. That's
offensive
why
of that, my lord,
we
let
have
him be.
been, we have been submitting it. before
Because
the
this is the contents of the order is that.
My lord, the order is very clear.
Paragraph
my lord.
page 62.
Just a moment.
It is the coordination is required in regard to, my lord, for implementation of the order. Finance
In the year-
department and the urban bodies.
My lord, in the year 2023, we have requested the commissioner to provide the grant in aid. It's a constitutional provision. They are to obey that. They are doing nothing, my lord. Unless the fund is there, my lord, we cannot give all these things. And this
No, you
scheme
see,
has come.
we will tell you, Mr. Datta. I am a bit old fashioned in this matters. You better file an affidavit.
I
Saying
can do
that
that.
these are the bottlenecks which you are facing, then we will sort of kind of impede them.
No, that can be done, my lord. Your lordship kindly see. Now, supposing the commissioner.
Today, even for good things today, I don't have time. There is a administrative work activity has to be.
No, your lordship can fix on.
Well, they have already filed affidavit, my lord.
We'll
No,
fix
no,
it up. No, this
affidavit in
is a
regard to
last.
this paper.
This has come because of the direction of this court to place instructions before us. So Mr. Datta has done rightly, complied with the order of the court.
Your lordship can fix on 11th.
The learned counsel for the Mr. B.D. Das, and senior counsel, assisted by Mr. Das, assisted by
The J. Lotha is there, my lord.
Mr. J. Lothal, and counsel for the petitioners. Also heard Mr. S. Datta, and senior counsel, assisted by Mr. S. Datta, and counsel for respondent number.
Respondent.
Six. Who are the other respondents? Mr. H. Alia, as well as Mr. H. Alia and counsel for respondent number 4. So this is, this takes care of. Who is for 1 and 2?
1 and 2.
They are all represented by government advocate. In terms of Rule
No,
5 of the
there's-
High Court rules, the
there's
lordship may
no-
ask the government advocate to take instruction from them. my lord.
No, we'll ask their personal appearance if they don't
Yes,
come.
yes. That is what is required. Without that, nothing is going to be complied with.
None appears on call for respondent numbers 1, 2,
And 3, my lord.
3 is Mr. Datta.
Datta is there.
She is, my lord, she has been transferred. She is not necessary, my lord. 6 is appearing. Even 6, my lord, she has been transferred.
And who is appearing for 4?
4 are appearing.
And 5? 1, 2, 5. 1, 2, and 5. Who's top? Is there Vakalatma on record?
Our Kalatma is there.
No, the other ones. No. Who's top?
Actually, SP Chaudhary, there's some names are showing for respondent number 2.
Oh, yes, SP Chaudhary. SP Chaudhary is, my lord, representing the number 2. Somebody is here.
K. Vishwakarma is also there.
Okay, none appears on call for respondent numbers 1 and 4. So it appears that the respondent number 3 has been transferred, and accordingly, as per office note dated 19/11/2025, the Silchar Medical Board has refused to accept notice. So Accordingly, the petitioner shall record. Next para, as the respondent numbers 1 and 4. Not present or represented, comma. The court has no option but to issue a direction for the personal appearance of respondent numbers 1 and 4. Okay, here for 4. So 1 and only 1. Two, we don't know.
What it look like.
All this is showing a name, Lordship. All this is showing a name for the respondent number 2.
Okay, 2 is Pranati Gogoi. Okay, just say that in respect of respondent number 2, Srimati Pranati Gogoi, the acknowledgement card is acknowledgement card after service of notice is available. So she is also not entered appearance. So therefore, the court is inclined to direct the personal appearance of respondent numbers 1 and 2. Next para, the petitioners 1 and 2, the date of their appearance is fixed on appearance, personal appearance is fixed
11
on.
minutes.
Next para, the said respondents are put to notice that on their failure to appear in person on the date fixed, comma, the court would be compelled to issue a bailable warrant of arrest. Next para, the petitioner shall take steps within 2 days or 2 working days for service of notice on the respondents 1 and 2 for their personal appearance.
But the government advocate can also, my lord, apprise.
No, not required. If they don't appear, how can we compel? We
My
can't
lord,
issue
my lord.
compelling
No, no.
orders on the lawyers. The learned counsel for the petitioner is at liberty to collect the posted receipt number and submit posted track report prior to the next date of listing. Next para, the learned senior counsel for the respondent number, Mr. Dutta, you are for 3? I'm for 6. 6. Yes. Has produced a copy of instructions pursuant to order dated 27/7/2026. Full stop. Due to paucity of time, the same could not be perused. Full stop. Accordingly, for considering the instructions produced by the learned senior counsel for respondent number 6, comma, list the matter on, give a date, a day after tomorrow. 11th. 11th. No, this is only for looking at this.
That's all right. I'll also submit 1 or 2 paragraph of a judgment, my lord. Your lordship will look into it. We are in great difficulties, man.
You want it on 11th?
Yes, my lord.
Okay, 11th. If
As
that-
Mr. Datta says, my lord.
The instructions are written to be produced on the next date of listing. This concerns. Take that.
Now, personal appearance date has to be there.
We are given a
Personal
date.
appearance.
We are given a date.
My
My
lord.
lord, in case of, my lord, filing of affidavit, in that case possibly at least 1 week time.
Pardon me.
We have to file an affidavit in. the
Instruction is
context of-
already there, my lord. Instruction is already there, my lord. Your lordship will take care.
Whether affidavit is required or not, we are not saying anything.
My lord.
All right.
Let it
In
be
that
on.
case, my lord,
Court
let-
says that produce instructions.
All right.
Let us see that.
That will-
I don't have
that-
time. I've already
Yes, all right.
asked my time.
May I please, Lordship?
No, item now 12